Pardon to make a mention, my lord. Criminal appeal of the year 2020. The petitioner is in custody for about 10 years. My lordship has.
Yes.
My lord, pardon to mention for modification of order.
Give.
Supplemental list. Item number 1.
May I please? Lordship's pursuant to your lordship's order.
Premature. Came for the premature religion bail, and that was rejected by the review committee. State Sentence Review Board.
What is the report?
Not falling under that category. Have you filed any application for bail?
Yes, lordships.
Pending.
Yes, lordships. Pursuant
Well,
to
that letter of the Chaudhar, senior superintendent, which is submitted here with
in IA, lordship.
no, we are not state council.
The order refers,
Yeah.
report refers to it.
He has served 13 years, 6 months, 20 days as actual imprisonment as on 7/2/2025. As per the Odisha Gazette notification dated so and so, presently the life convict so-and-so is not eligible to be considered by the so-and-so, a copy of the letter received from the senior superintendent is submitted herewith. Where is that letter and where is that notification?
That notification is nothing that. We shall next page show that that is the 14 years in the custody and this other two guidelines.
Shall be eligible to be considered for premature release immediately after serving out the sentence of so-and-so of actual imprisonment without a.
And he
ବର୍ତ୍ତମାନ ଯଦି ଏତେ 13 ବର୍ଷ 6 ମାସ ହେଇଗଲାଣି ତା କେସ୍ ତ ବର୍ତ୍ତମାନ ହେଇଯିବଣି
ଆଜ୍ଞା
ଏଇଟା ଆପଣଙ୍କର ଯଦି
For the purpose of premature release, you don't consider remission? Actual sentence.
actual
ହଁ ଆକ୍ଚୁଆଲ ସେଣ୍ଟେନ୍ସ ଟା ଆପଣଙ୍କର
13 ବର୍ଷ 6
13 ବର୍ଷ 6 ମାସ ହେଇଥିଲା କେବେ
ଫେବୃଆରୀ 7
7/2/2026 ତ ବର୍ତ୍ତମାନ ତ 14 ବର୍ଷ ହେଇଗଲାଣି
But whether it is
Other
this
thing is
including
very-
remission or not has to
ନାଇଁ 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 ଆକ୍ଚୁଆଲ ନାଇଁ ଏଇଟା ଲେଖିଛି ଆଜ ଆକ୍ଚୁଆଲ
actually.
ତେଣୁ ବର୍ତ୍ତମାନ ଇଏ କଲେ ପ୍ରେସ୍ ଇଏ ଦବା କଥା ତ ଏଇ ଗ୍ରାଉଣ୍ଡରେ ଯଦି ରିଜେକ୍ଟ ହେଇଥିଲା
and there are other things is there.
no you are not telling the other things you are telling that he could not be considered because of this you are not telling that for other reason his bail up that was rejected only on the ground that he was not for actual imprisonment for 14 years that is why his case was rejected so now since he has completed that period so the again the recommendation is to be made
Because
That is
as
to-
on 7th February 2025,
2025
this was 6 months ହେଇଗଲାଣି.
So take instruction
48.
whether that has been press recommendation has been made or not. We follow. And in case we grant him bail, that would create another difficulty. Right?
ତାର condition ବୋଲେ ତାର potential he may be made a crime or not that age is 28 years
38
in the year 2012
38 years.
38
38 years ସେ ବୋର୍ଡ
ଆପଣ ଅନ୍ୟ କୌଣସି କାରଣ ପାଇଁ ରିଜେକ୍ଟ କରିନାହାନ୍ତି ଆପଣଙ୍କର ରିଜେକ୍ସନ ଅର୍ଡର ହଉଛି ସେଇଆ ସେଇଥିପାଇଁ ଆମେ କହୁଥିଲୁ ଯେ ସେ ଇଏଟା କାହିଁ ଯୋଉ ଲେଟରଟା କାହିଁ ରିସିଭ୍ ଫ୍ରମ୍ ଦି ସିନିୟର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସବମିଟେଡ୍ ଲେଖନ୍ତୁ
But 3 years ତ ହେଇଗଲାଣି.
they are to-
Bail କରିଦେଲେ 3 ମାସ ପାଇଁ.
Hmm.
Consider କରୁଥିଲେ କଣ ଅଛି problem?
Hey, we can take it after
ହଁ ହଁ. That
so that you let him instruction.
ଯଦି
bail
premature ହେଇଯାଉଛି then we need not
ହଁ.
consider all. Yes.
Listen. As for the order dated 5/11/2024, where this court directed that if the application filed by the appellant for premature release on 29/2022 has not yet been considered, the same shall be considered in accordance with law, keeping in view the observation made by the Honorable Supreme Court in the order dated 22/10/2024. Passed in SMW Criminal number 4 of 2021. Today, the Learning Council for the State has produced the written inspection dated 18/2/2025 received from DIG of Prisons Headquarters, Odisha, wherein it is stated as follows. Quote kar devo purada. On a reading of the aforesaid written instruction, it appears that as on 7/2/2025, the appellant has served actual imprisonment for 13 years, 6 months, and 20 days. Stop. Learned counsel for the state has placed the Law Department resolution, Government of Odisha dated 19th April 2022, where guideline for premature release 2022 has been mentioned. And in clause 5, which deals with eligibility for premature release, it is stated that every convicted prisoner, whether male or female, undergoing sentence of life imprisonment and covered by the provisions of section 433A of CRPC, shall be eligible to be considered for premature release from the prison immediately after serving out the sentence of 14 years of actual imprisonment, that is without the remission. Stop. Since in the case in hand, the appellant's premature release was not considered on the ground that he has not served out the sentence of 14 years of actual imprisonment as on 7/2/2025, since in the meantime he has already completed 14 years of actual imprisonment, the Learned Counsel for the state shall obtain instruction whether any recommendation has been made for premature release of the appellant to the jail superintendent. The report be furnished by the next date, which is fixed to at a chutti on 10th October 2025. Three copy of the order be handed over to the Land Council for the state. This is taken on the top.
Item 2.
If the recommendation has not yet been made, the concerned jail superintendent shall assign reason as to why the same has not been made. Yes.
Item 2.
Yes, Mr. Biswal Surendra Kumar Biswal and S. Das. They have 5 vocals. Prisoner's petition to ଅଛି ନାଁ ଅଛି ତାଙ୍କ ନାଁ ବି ଉଠିଗଲା वकालतनामा भी पठेई ଦେଇଛି ସେ ସାଇନ୍ କରିକିନି बट बाबू किए ତାଙ୍କର नंबर फोन नंबर किए ଅଛି सुरेंद्र कुमार विश्वास नंबर ଅଛି फोन नंबर ଅଛି तो ई साहू सॉरी फोन नंबर दिया है रिंग कले तांको दिए हला ଆଉ ଜଣଙ୍କୁ ପଠେଇକି ଟିକେ ରିଙ୍ଗ କରନ୍ତୁ ତାଙ୍କୁ କୁହନ୍ତୁ ଆସିଛି କଣ ପାଇଁ ସେ ଆସିନାହାନ୍ତି। ଲେଖିଦେଲେ ନମ୍ବର ଲେଖିଦେଲେ ନେକ୍ସଟ ଟାଇମ୍ ପାସ୍ ହଉ।
Item 3.
Last occasion was pleased to suffer an instruction. The custody certificate in this case has been filed.
Custody certificate 3 years 7 months.
Where the FIR is of the year 2008.
You know, the custody certificate was 3 years 7 months.
Where there is some discrepancies with regard to that.
He is not happy with this one.
On the last occasion also there was some discrepancy.
There are two eyewitnesses.
One is the,
We want to first to know that custody period ଟା କେତେ? ଆପଣ ଯୋଉ custody certificate ଟା ଦେଇଛନ୍ତି
madam,
ତା ଦେହରେ କେତେ ଲେଖିଛନ୍ତି custody ଆପଣ ଦେଖୁଛନ୍ତି ନା ଟୋଟାଲ ଇଏଟା ହଉଛି 3 ବର୍ଷ 7 ମାସ ଇଏ ଯୋଉଟା କଣ ଦେଇଛନ୍ତି 1/8/2016 ରୁ 5/5/2017 ଏଟା ଥିଲା ସବ୍ ଜେଲ୍ ବରବିଲରେ ତାପରେ 2/5 ଥିଲା ସବ୍ ଜେଲ୍ ଇଏ ତ ଏଇଠି ଯଦି ଆମେ ଦେଖିବା ड्यूरिंग ट्रायल ସେଟା ହେଲା 16 ରୁ 19 ତ 2 ବର୍ଷ କେତେ ମାସ ହେଇଗଲାଣି ଏଠି 2 ବର୍ଷ 4 ମାସ ତାପରେ ଥିଲା ସବ୍ ଜେଲ୍ ଚମ୍ପୁଆରେ ଥିଲା ଏ ପିରିୟଡ ଏ ଯୋଉ 2020 ପରେ କଣ ହେଲା 7/3/2020 ପରେ କଣ ହେଲା
ସେଟା ଆଉ ଗୋଟେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆସିଛି ସେଟା 8 ବର୍ଷ 9 ମାସ ଦେଖଉଛି
ମାନେ ଆକୁ ଇନକ୍ଲୁଡ କରାଯାଇଛି
ଇନକ୍ଲୁଡ କରିକି
ଦେଖନ୍ତୁ ସେଟା କହୁନାହାନ୍ତି ଏଇଟା କଣ
ତାଦେହରେ ସେପାରେଟ କରି ଦେଇନାହାନ୍ତି
ନାଇଁ ଯଦି ଏ ପିରିୟଡଟା ତା ଦେହରେ ମିଶ 1/4/2016 ହଁ ଏଟା ଇନକ୍ଲୁଡ କରାଯାଇଛି ତାହେଲେ ଟୋଟାଲ ପିରିୟଡ ଏଇଟା 3/5 8 ବର୍ଷ 9 ମାସ କହୁଛି whether your bail application was rejected earlier.
No, this is for the first time.
$302 case.
Right. Lordship,
What is the allegation?
but the eyewitness wife.
ଛୁଆକୁ ପଛେଇ ମାରି ଦେଇଥିବ
Your Lordship has heard it extensively, man. We read at page 33 of the paper book.
EW6.
Yeah.
EW6.
6 and 7.
6 and 7. 7
7 is
minor.
the minor
Sir,
No, whom he has killed.
Milord, a minor son of
Another son was killed by his father.
father. The father is before your lordship.
appeared along with her niece on shore of the place she was as a food. Then got the son while she was returning from school. Soon was found that there was a gathering of people in the school. She sent to know that as a younger son, so 3 years, throwing him on the ground, that is by the gathering.
Rule 7, that is the 13 years, 5 years.
Yeah, just to refresh your
Why?
lordship's memory, my lord.
Just a minute. That is why we wanted to know what is the
My,
Status of the
PW7.
six and seven.
my lord.
PW7 is now reading in class 7.
And staying in the ashram.
कान्हा कारू आता ना
हाँ, Karnataka.
He says, he claims him to be
And
his
the
son.
mother,
His son.
wherever the mother is not known. So, se
Hmm.
chhadi ko na pade jinse.
Mother is
Ta maa je.
also
The Pedal 6.
married someone else.
And not known his whereabouts, what my London friend is.
As the report shows that thereafter he is staying with another person there.
Now, the father is the best person who can take care of that child.
You have rightly taken care of one child.
But that was out of grave and sudden provocation, it's transferred from this.
there is no question
Total
of
healing.
there is no question of handing over this child,
My,
even if at any point of time you are released on bail.
my.
Why don't you come in contact with this? ये तो तार आश्रम में अच्छी ना और
You must differ how
नहीं he shall not come in contact with this. You know,
এই যে পিলাটা আছে সে সিপ্রিম কোর্টে ওর নিজে কোর্স এই নিজে কোন আইলি মার দাও
যে
তার নিজে কোর্ট
ये बोलो ना आई इतने से साल तो कोई चीज हो सब तक को मेक इन्फॉर्म करो
and he also small boy
12 वर्ष
visa
12 वर्ष पिलर
at least he is settling there.
IA number 117 of 2025. There is an application for bail. The London Council for the State has produced written instruction from Superintendent District Judge Keonjhar, which shows that dated for the 25/6/2025, it shows that the petitioner has remained in custody for 8 years, 9 months. And therefore, by now he has completed 9 years in judicial custody. It is further stated that the conduct of the appellant in jail was satisfactory. The report is taken on record. The Land Council for the State has also produced written instruction, a trial court report of that PW7 Anha Karua was is an eyewitness to the occurrence and deposed against his father, to appellant, is now aged about 12 years and residing in Adruto Children Ashram, Naranpur, since last 5 to 6 years and starting in class 7. Since the prosecution case is that the petitioner has killed his minor son, এটা হচ্ছে sole eyewitness,
6 years old.
6 and 7,
mother and son.
which is based on the eyewitnesses account of not only PW7 but also PW6, comma, the wife of the appellant. ତାର ବର୍ତ୍ତମାନ whereabouts କଣ? ସେ କୋଉଠି ଅଛି ନା ଜଣା ନାହିଁ।
Not to she mail it somewhere else.
ଆଜି ଲେଖା ହେଇଛି।
ସେ ରିପୋର୍ଟ ସୁବିଧା ସେ ତାଙ୍କ ବାପାଙ୍କ ଘରେ ଖୋଜିଲେ
ସେ
ମଧ୍ୟ
କୁଆଡେ ପଳେଇଲା ପରା କାହା ସହିତ?
ଛାଡ ଦିଅ। In view of the available material on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention, judicial custody, we are inclined to release him on interim bail. And keeping in view the ratio laid down in the case of relative versus funds, we are inclined to release him on interim bail for a period of 3 months. During the interim bail period, the petitioner shall not try to come in contact with either PW6 so and so or PW7 so and so. Violation of any terms and conditions and until cancellation of this. Yes, next.
May I present this order may be communicated to the jail authority
Okay,
directly?
yes, next.
My problem.
So, sir, I don't know to which concern. I have contacted, but they are saying that I am in the distance space.
They are not interested now. It is because of that petition we engaged him. Now, I would think of non-appeals for the petitioners, appellant for them. The name of Mr. Profuller author 2 shall not be reflected in the cause distance for. Put up this matter on 24th September 2025. The Land Council for the state shall obtain the custody certificate and also the criminal antecedent and jail conduct in the meantime. Yes, next.
Item 4.
So if I may please the lordships.
Is the period undergone?
My lord, in custody since 13/5/2018.
Have you taken all those documents?
I have it.
What is the offense here?
My lord, 302, initially 340, subsequently converted to 302. The FIR
How
was
many death has taken place? One deceased or more?
one deceased, your lordship.
Eyewitness is there.
There is one eyewitness,
Who is he?
PW5.
And the doctor?
Doctor is PW9.
What is the weapon of offense?
One axe.
How many blows were given?
My lord, as per the doctor, 5 injuries.
Five injuries only. What period you said that he was in custody?
In custody since 13/5/2018.
So have you got that custody certificate? What about the criminal antecedent?
And we have to solve it.
Get it?
Yes, sir.
Next week for them. Learning counsel for the Mr. A. Saurabh, learning counsel appearing for the appellant service that the petition is in judicial custody since 13/5/2018. However, he is not having any custody certificate. Learned counsel for the state section branch to obtain the custody certificate. Also instruction regarding the criminal antecedent, if any, against the appellant. So also is conducting here. Both of this matter on 24th of September 2025. Yes.
Item 5.
Name business. I have filed a IO for bail. Offense under section 302. Contents to undergo arrest for life and a pay of fine of rupees 50,000. Occurrence eyewitness, PW 14 and PW.
You are in custody since?
Since custody since
6
2017.
2017.
6/2.
8 years, 6 months.
6/2/2017. That is the final form.
Arrested 6/3.
Huh?
Arrested 6/3.
Final form video Kumar Shetty to
Yes, sir.
লেখা হয়েছে প্রায় ঠিক
IU evidence to 6.
হ্যাঁ
IU evidence to 6/3.
লেখা হয়েছে এটি 6/2017
Arrested 6/3.
6-3.
ଘଟଣା କେବେ ହେଲା 5/2 ରେ ହେଲା
5/2.
ଆଉ 5/2 ତା ପରଦିନ
ହଁ, ଦୁଇ-
ଆରେଷ୍ଟ ହେଇଥିବ ଆଉ କଣ ଆଇଓ କିଏ
IU PW 18.
18
Application ରେ ଆପଣ ଲେଖିଛନ୍ତି 6-3.
5/2 ରେ ଭିଜିଟ କଲ ମୁଁ କଲି after swan soon. ହଁ এবার কହୁଛି on এটি clearly কହୁଛି paragraph now on 6/2/2000 on 6/2/2000 I forwarded the accused to the court.
Page 56.
ବର୍ଷ
8 years.
7 ମାସ
Jail conduct thing, right?
We have to obtain that.
The allegation against him?
Eyewitness, who is eyewitness?
Eyewitness PW 14 and PW 14 the child witness.
PW
10.
14.
He has killed a lady, the Sukhanti Sethi.
Sukhanti Sethi is the deceased.
Sukhanti Sethi আর কোন হবো কি? Appellant?
ତାଙ୍କର ପଡିଶାର ପିଲା 10 years ପିଲା
আর Sukhanti Sethi age ହଉଛି
ନା ନା
10 years.
witness PW 14 years of 10 years.
No, we want Sukhanti Sethi କିଏ?
Sukhanti Sethi the deceased. The PW 1 is the husband of the Sukhanti Sethi.
While the
PW
informant
who is
was
the-
its of one of the neighbors also came, stated that the wife of the informant was murdered by the accusation. Informant rushed to the house, found his wife lying dead. He asked his son, who stated before him on his return home. He found that his uncle, or they are related to each other, right?
Yes.
Assaulting us.
Never.
That means it's a brother-in-law.
Brother-in-law.
His brother-in-law.
I think
A single blow.
single blow. Only
Single blow by a rectangular bar. Wooden bar
Gajja
used
body.
by the master.
ये PM doctor की है
Doctor are not examined.
Doctor not.
Not examined.
अरे खाली ये जो ये evidence टा
Evidence is the IU evidence is the.
Doctor's report is exhibited.
Exhibited by inquiry report, only inquiry report, exhibited by the IO.
It is by a wooden bar লেখা আছে।
Rectangular wooden bar.
ଗଜବାଣୀ
ରାଜମିସ୍ତ୍ରୀ
ରାଜମିସ୍ତ୍ରୀ ଯୋଉଟା କାମ
ଗଜ ଯୋଉ ଗୋଟା କାଠ
And given a single blow.
very strong bar.
What is that exhibit of the PM report?
PM report.
PM report has not been.
No, exhibited. Judgment লেখা ହେଇଥିବ ନା। PM report, exhibit 17. এটি lacerated wound, fracture of the skull. Also, external appearance of Koshi injuries on from the 7 inch into 3 inch into 2 inch. Yeah. Sanctions after 15 injuries on cause of death is done.
Single blow.
Or the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits as the petitioner who is in judicial custody since 6/2/2017. And the petitioner is the brother-in-law of the deceased, Sukhanti Sethi. And PW 14 is the minor son. PW 14 ଟା ହଉଛି ତା ପୁଅ ତ?
ଆଜ୍ଞା
ତା ନିଜ ପୁଅ ନୁହଁ,
ହଁ
ତା ନିଜ ପୁଅ ନୁହଁ, ତାର ପଡିଶା ଘରର ପିଲା।
ଆଚ୍ଛା।
ତାକୁ ମା ବାପା ବୋଲି ଡାକେ।
Acha, okay. PW 14, the child witness is the eyewitness to the occurrence, and he has stated that the appellant assaulted with a wooden rectangular bar to the deceased. Single blow, dealt a single blow on the head of the deceased. Learned counsel further submits that the doctor conducting postmortem examination has not been examined. However, the PM report has been proved through the investigating officer and has been marked as Exhibit 17, which indicates that cause of death was due to hemorrhage and shock on account of injury to the vital organ, that is brain. He further submits that since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail. Place the
two and two be a witness.
Huh?
Two be a witness.
Two is not occurrence witness, but
No,
he is not alleged eyewitness. He is
I
not.
was a distance of 100 feet from the body of house. I saw the accused assaulting my mother Sukhanti by mason Gajwadi. By head of
Rajawadi.
3 to 4 blows.
PW learned counsel for the state on the other hand, that apart from PW 14, PW 2 has also stated about the assault on the deceased by the appellant. Considering the submission made by the learned counsel for the respective parties, nature of evidence available on the period of detention of the petitioner in judicial custody for more than 8 years and 6 months, in absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes, next.
Item 6. Madam.
My lord, therefore bail IN number 268 2025 offense committed under section 302 of IPC.
Just a minute. Prisoner's petition has been received for engagement at one, so. Have you filed the वकालतनामा?
My lord,
वकालतनामा देखिए मैडम करो. हाँ, ठीक है. Listen, prisoner's petition has been received from jail, wherein prayer has been made for engagement of advocate Binapani Tripathi and Nandini Tripathi as their counsel, as his counsel in place of earlier engaged counsel. The Ms. Binapani Tripathi as well, and the associate has filed वकालतनामा, which is accepted. The name of Mr. Vikas Chandra Parija shall not be reflected in the cause list henceforth. Yes, what is your submission?
my lord, date of occurrence 9/6/2022 and date of arrest 11/6/2000.
11?
11/6/2020. Not a occurrence like that arrest. Custody period 3 or 3 months. My lord, PW 7, 8, 9. 3 eyewitnesses. My lord, weapon of offense bamboo lathi.
7, 8, 9.
Seven,
Come to PW7. Read it. Paragraph 2. Are you having the deposition copies with you?
my lord,
7 number ta पकड़. Balokeshwar Singh.
my lord. My lord.
Para two.
Vijayamanji
Para 2 ta पढ़ो.
Obviously died about me that on the date of occurrence at about 1 p.m. While I was taking lunch in the place of my work, I will farmhouse Behera Babu and Kapreshwara Mandira Govardhana Mandap. The accused and Biramaji arrived that on a motorcycle. While both of them were there is the place I was taking lunch, I waited for my work inside the farmhouse. In the evening, when I returned to my room, I watched the accused along with Biramaji were cooking food. Telling from a cook carry, I am a take book.
I went to take.
To take bath. Nearby.
You well.
Nearby tube will.
You well.
I saw. Will be to when I returned after taking bath. The accused. The cooking book telling them I want to take bath to the nearby to be we. There will return after taking bath. The accused and the deceased were not there in the night at 10 p.m. Just that. The accused and Biramaji and return while quarrying. With each other.
Sudden Pavitra Mirdha. Which resulted in sustenance of the bleeding injury on his face. So,
Who is the doctor?
Dr. PW1. Number of injuries.
Number of no matter number of injuries. No time, yeah, no.
PW1 कहीं.
Page 54.
6 injuries.
6 injury.
Lacerated.
Hmm.
On,
appears to be single blow.
no mention, bamboo lathi.
ছটাই single blow, ছটাই
যাও
Sudden provocation ହେଲେ
provocation
ଛଅ
ଛଅଟା ହବ।
କରିଥିଲେ ତାଙ୍କୁ ଦେଇଦେଲା।
okay after the holidays next
Item 7.
Continuous statement.
next item number 7.
May I please Lordship, madam? The father killed his son, man. The allegation is that. I'm in custody since 26/10/2020. 2020.
2020.
Informant himself turned hostile man. He is saying the police directed me and as per the dictates of the police, I subscribed the FIR.
PW8 is the eyewitness.
Hmm?
PW8 is the eyewitness.
8
Yes, grandmother.
The deceased was sleeping with her.
PW8 হচ্ছে grandmother
Then
who is an eyewitness to the
They
occurrence.
witnessed, yeah.
Who is the doctor?
Doctor is married.
Six year.
Huh?
PW6.
6 is the PM doctor. So lacerated wound on the bridge of the nose to the
Masked by
lateral
stone.
wound of swan stone.
Weapon of offense is the 20 kg stone.
Stone.
Triangular piece stone.
Then he smashed him on a stone.
I was sleeping with the deceased in the hollow room. My daughter had been to front. The accused came.
The accused came and took the deceased and smashed him on a stone, for which the deceased sustained injury.
What is the relationship between the appellant and the deceased?
Appellant is
Father.
son-in-law.
Son-in-law?
Yes.
Father of the
He
deceased.
was saying.
Just a minute.
The father of the deceased.
Appellant is the father of the deceased.
The appellant used to stay in his in-law's house.
Here.
Appellant.
Hmm.
ତା ସ୍ତ୍ରୀକୁ ଖୋଜିଲା ପାଇଲାନି ତ
ସେ ରାଗରେ
ପୁଅକୁ
ପୁଅକୁ
ମାରିଦେଲା। That is the explanation. PW2 ଯାହାକି ସେ extra judicial confession ହେଇଛି।
2.
PW2
ନା ତାକୁ ବାନ୍ଧି ପକେଇଲେ ସବୁ that is saying is extrajudicial but they
ନା ବାନ୍ଧି ପକେଇଲେ କିଛି ନାହିଁ। May I place the PW2 image? The occurrence took place 2 years back.
Evidence ପଢୁଛନ୍ତି PW?
2.
ଆପଣ?
Extrajudicial.
The second part, the occurrence took place about 2 years back at night in the house of Bonnamali Dehuri, where the accused was staying. Bonnamali Dehuri is the father-in-law of the accused. In the morning at about 7 a.m., I went to the house of Bonnamali Dehuri and found that the villagers had tied the accused to a pole near his house. I went inside the house and found the dead body of Sudan Dehuri lying there. I found that there was Pathara Checha Mada on his head. I came outside and asked the accused as to why he had killed his own son, Sudan Dehuri. At this, the accused replied that as he could not find his wife in the house, he got angry and killed Sudan Dehuri.
ତା ସ୍ତ୍ରୀକୁ ପାଇଲାନି ବୋଲି ଆକୁ କାହିଁ ମାରିବ? ପୁଅକୁ କଣ ପାଇଁ ମାରିବ?
PW2 is saying I have no direct knowledge.
No, that's not the point.
And PW2 cross-examination, he said.
I have no direct knowledge.
No, direct knowledge, he has not seen the occurrence. Then he said the accused had told me that he killed son as he could not find his wife.
Then he could have lost
What
the
is the age of the deceased?
5 years.
5 years?
Yes.
Very small.
Oh.
PW2 तारा first para देखो जो was 5 years old. The time is.
I was saying I received a telephone call, but who telephoned him? That telephone number.
So that ought to be considered at here. Telephone call.
It's a brutal killing.
Video son,
5-year-old child.
5 years old.
PW8
And
is
he has
saying
no fault.
And
Wife
apparently the own
wife
brother-
has gone somewhere. Why would kill a small child of aged about 5 years after vacation? Next.
Item 8.
may please the Lordship, madam.
Yes.
Initially, FIR was lodged under section 307. the deceased were admitted to the hospital and they are discharged from the hospital. After staying in his house for 4 to 5 days, he expired. So 1 month man.
After 1 month.
PW10 is the doctor.
10 is the doctor, he is a pediatric doctor.
Doesn't matter.
And he is saying
The fracture on occipital bone, fracture on right,
The accused has killed.
the brother, man, 2 brothers.
elder brother.
Accused is the elder brother.
Deceased is the elder brother. PW6 is the eyewitness. The only
Six is
eyewitness.
the eyewitness.
6 is the eyewitness.
W6 ala eyewitness.
Yeah.
Now, who is the doctor?
PW10.
10 doctor.
3 and 8 are the
Still the doctor is saying on 25/1 I conducted PM.
Gopal, and the occurrence took place on deposing Swansea. There was Sunday at about 3 p.m. Then my grandfather returned to his house. After paying
the pain accused went and assaulted my grandfather with a bamboo stick at his head. I was alone at the house.
Seen the action.
Oh, nice. Thereafter, my grandfather fell down under bleeding condition. I went and narrated the incident to my sister Maya Murmu, who is PW8, and my brother-in-law is PW3.
What is the PM report? That's PW10 probably.
PW10 doctor.
Fracture of occipital bone. Also, my cause of death is due to head injury. And since when you are in custody?
I was in custody and they have to release on bail, man.
Oh, sure.
I was in custody since 26/1/21 to 22/8/22. This honorable court granted bail.
26,
1
21.
to 22/8/22.
Okay.
I was released on bail 3/8/22. Around Honorable High Court heard the case there is no
Then,
litigation.
after the conviction, you are in.
Yes,
That was judgment was pronounced on 29/8/2024. अभी कितने बेसी नहीं बहुत से तार क्रिमिनल एंटीसीडेंट और जेल कंडक्ट आफ्टर पूजा हॉलीडेज को नेक्स्ट
Right.
Item 9.
Apparently, the mother-in-law of the deceased, she faced trial for charge under section 498 304B 302 IPC, section 4 of the DPA, acquitted from all charges and but convicted under section 302 IPC and life imprisonment and fines. Well, the entire case rests on the 2 sets of evidence. One is oral dying declaration before the fireman. Then another is exhibit P5, which is the recorded dying declaration by the doctor PW
11.
PW11.
PW11
and PW15 was present with the nurse.
and PW15 was present.
That is the
You
exhibit.
come to PW 11 7.
My lord. I was serving the casualty and consoles also. The patient was well oriented and the patient recognized herself and she is in DHH Keonjhar at night and recognized sister and doctor on duty. The declaration of the patient is written. He is not said and only
ମୋର ସାଙ୍ଗ ସହ ଫୋନରେ କଥା ହେଲା ବେଳେ ଏକ୍ଜିବିଟ୍ 5
five.
ମୋର ଶ୍ୱଶୁର ମତେ ଗାଳି କଲେ ଆଉ କହିଲେ ବହୁତ ଦେଖେଇ ହଉଛୁ ମୋର ଶାଶୁକୁ ଡାକିଲେ ଆଉ କହିଲେ କିରୋସିନ ଆଣ ଆକୁ ଆଜି ପୋଡ଼ିଦେବା ତାପରେ ମୋର ଶାଶୁ ଓ ଶ୍ୱଶୁର ଦୁହେଁ ମିଶି ମୋ 2 ଗୋଡ଼କୁ ବାନ୍ଧି ଦେଲେ ଆଉ ଇଟାରେ ମୋର ମୁଣ୍ଡ ଆଉ ମୁହଁକୁ ପିଟିଲେ ତାପରେ ଶାଶୁ ଆଣି କିରୋସିନ ଦେଲେ ଆଉ ଶ୍ୱଶୁର କିରୋସିନ ଢାଳି ନିଆଁ ଲଗେଇଦେଲେ ଆଉ ମତେ ଘର ଭିତରେ ଛାଡି ବାହାରକୁ ଛୁଟି
No. Mallet, husband, father-in-law, he died due to burn injury.
after puja holidays stay relation of mine. Yes, next.
Item 10.
Plain Mallet, convicted under Mallet Foxer
Notice ଯାଇଚି?
notice जाइए appear करते हैं victim is PW मतलब 2 PW victim is PW 2 मतलब sorry become hostile
17 years on the CGT4.
what's the kind of the victim status
The informant is my mother. I am the victim of the case.
PW 2 is the victim.
PW 2, brother. I know accused Ananda Miya. The incident relates to the matter about 4 years old. I was a student, class 9. I was in love with the accused, led away with him.
She become pregnant.
My father so and so. The accused again took me so and so. I escaped relationship. Then scolded me, assaulted, denied to marry. I returned to accused again.